No one likes to think they'll have to deal with a staff disciplinary situation, such as misconduct or poor performance. But it does happen, and it's important that you, as an employer, have a disciplinary procedure in place that's fair and transparent. Your disciplinary procedure should be in writing and be easily available to your staff. It should state what performance and behaviour might lead to disciplinary action and what action you might take. It should also include the name of someone your employee can speak to if they don't agree with your disciplinary decision. It is important to carry out an investigation of a potential disciplinary matter without delay to establish the facts. The investigator could be a member of your staff team or an external investigator with experience in HR. The investigator should not have any involvement in the case. You may decide that an employee should be away from work whilst you carry out the investigation. In cases where a period of suspension with pay is considered necessary, this should be for as short a time as possible. And it should be made clear in a meeting that this suspension is not considered a disciplinary action. The investigation is to help you decide whether there is a disciplinary case to answer or not. The investigator's role is to work out the facts and determine what happened. The investigation may include speaking to witnesses, speaking to the employee who is the subject of the investigation, and gathering various documents. At the end of the investigation, a decision will be made as to whether no further action needs to be taken or whether there is a disciplinary case to answer. If it is decided that there's a disciplinary case to answer, the employee should be notified in writing. This notification should contain sufficient information about the alleged misconduct or poor performance and its possible consequences. It should also include copies of any written evidence, which may include any witness statements. The notification should also give details of the time and venue for the disciplinary meeting and advise the employee of their right to be accompanied at that meeting. The person or people hearing the case should not have any involvement in the case that is being considered. At the disciplinary meeting, the employer should explain the complaint against the employee and go through the evidence that has been gathered. The employee should be allowed to set out their case and answer any allegations that have been made. The employee should be given an opportunity to ask questions, present evidence, and call relevant witnesses. After the meeting, decide whether or not disciplinary or other action is justified and inform the employee of your decision in writing. Your decision might be no action, written warning, final warning, demotion, or dismissal. The letter outlining your decision following the disciplinary hearing should also outline the employee's right to appeal and how they go about doing this. If there is to be an appeal hearing, once again, the person or people hearing the appeal should not have had any involvement in the events that are to be considered. Raise and deal with issues promptly. Act consistently. Carry out any necessary investigations to establish the facts of the case. Inform the employee of the basis of the problem and give them an opportunity to put their case forward before any decisions are made. Permit employees to be accompanied at any formal disciplinary meeting. and allow employees to appeal against any formal decision made.